Is New York a community property state? When it comes to the division of assets during a divorce, understanding the laws that govern property distribution is crucial. In the United States, different states follow distinct legal frameworks for dividing marital property. One common approach is known as community property, which ensures an equal split of assets acquired during the marriage. However, in the case of New York, things work a bit differently. This article aims to explore the question, is New York a community property state, and shed light on the unique laws and regulations that govern property division in the Empire State. Understanding property laws. The division of property in a divorce or separation hinges largely on the type of property laws that govern the state where the divorce is taking place. These laws primarily fall into two categories: community property laws and equitable distribution laws. What is a community property state? In states where community property laws apply, assets and debts acquired during a marriage, with a few exceptions, are considered community property. Community property assets include income earned throughout the marriage, items purchased by either spouse during the marriage, retirement accounts established during the marriage or contributions made to pre-existing accounts during the marriage, bank accounts and investments accumulated during the marriage, separate property transferred to joint accounts, separate property converted into marital property, such as when one spouse uses personal savings to assist in buying a family car under both spouses' names. What is an equitable distribution state? An equitable distribution state refers to a legal jurisdiction that follows the principle of equitable distribution when dividing property during a divorce. Property ownership in New York. In New York, an equitable distribution state, the principles of property ownership and its division during a divorce or separation aim to foster a fair allocation of assets and debts. Understanding these principles is essential, as they directly influence the handling of property acquired both before and during the marriage. Factors courts consider in equitable distribution. When it comes to distributing marital property in New York, courts examine a wide range of factors. Some of these include each spouse's income and property at the time of marriage and at the divorce filing time. This factor examines the financial situation of both spouses at the beginning of the marriage and at the time of divorce. The length of the marriage. The duration of the marriage plays a role in property division. Longer marriages often involve more intertwined finances, shared assets, and mutual contributions. The age and health of both parties. The age and health of each spouse can affect their ability to generate income, acquire assets, or find employment. If one spouse has health issues or is approaching retirement age, they may require additional financial support or medical care, which could be considered in property division. The need for the custodial parent to occupy or own the marital residence. When children are involved, the court may prioritize the well-being and stability of the custodial parent and the children. The loss of inheritance and pension rights upon the dissolution of the marriage. Divorce can lead to the loss of potential future financial benefits, such as inheritance rights or pension benefits. The court may take this into account and provide compensation to a spouse who would have had such benefits if the marriage had continued. Each party's contribution to the acquisition of the marital property. This factor recognizes both monetary and non-monetary contributions made by each spouse during the marriage. The tax consequences for each party. The potential tax implications associated with the division of assets can impact how they are distributed. Whether one party has deliberately wasted, transferred, or encumbered marital assets in anticipation of divorce. This factor focuses on any misconduct by either spouse aimed at depleting or manipulating marital assets. Separate property. In New York, separate property refers to assets or property that is considered individually owned and is not subject to division or distribution in the event of a divorce or separation. Here are the common categories of separate property in New York. Premarital property. Inheritance and gifts. Personal injury compensation. Property exchanged for separate property. Appreciation of separate property. Written agreements. Marital property. Marital property in accordance with New York law refers to all property obtained by either spouse or both spouses during their marriage, prior to the execution of a separation agreement or the initiation of legal proceedings related to divorce, regardless of the manner in which ownership is held. For an asset to be considered marital property in New York, it must meet the following requirements. Acquisition during marriage. The asset must have been obtained by one or both spouses after they legally tied the knot, regardless of whose name appears on the title or ownership documents. Timing. The asset must have been acquired prior to a legal separation or the commencement of a matrimonial action, such as filing for divorce or initiating other legal procedures related to the dissolution of the marriage. The definition of marital property is expansive and encompasses a wide range of valuable assets, including, but not limited to, real estate. Houses and other properties acquired during the marriage are classified as marital property. Vehicles and personal property. Assets such as cars, boats, airplanes, furniture, artwork, and other tangible items obtained during the marriage are considered marital property. Financial assets. Cash, cryptocurrency, bank accounts, stocks, bonds, retirement accounts, pensions, and other financial securities acquired during the marriage are categorized as marital property. Physical assets. Valuables like gold, precious metals, jewelry, and other tangible assets acquired during the marriage are considered marital property. Business interests. Any businesses, professional practices, or ownership interests obtained during the marriage are deemed marital property. Gifts between spouses. Gifts given by one spouse to the other, whether in the form of physical items or monetary value, are also considered marital property. Can separate property become marital property? In New York State, property acquired during a marriage is typically considered marital property, while anything owned by either spouse before the marriage, or acquired by them individually through inheritance or gift during the marriage, is categorized as separate property. Dividing assets in a New York divorce. When it comes to divorce proceedings in New York, an equitable distribution state, dividing assets can be one of the most contentious issues. Dividing a house. When it comes to dividing the family home in a New York divorce, the first step is determining its classification as either marital or separate property. Dividing debts. When going through a divorce in New York, many people tend to focus on dividing their assets, such as the house or their pension. Dividing retirement assets. Retirement assets, such as pensions, 401ks, IRAs, and other retirement plans accrued during the marriage, are considered marital property and are therefore subject to equitable distribution in New York. Contact us today at 347-212-5113 to schedule a consultation.